The Supreme Court chamber fell silent as Justice Ketanji Brown Jackson leaned forward, her insightful gaze fixed on New York State Representative Zohran Mamdani. The normally composed justice's voice, though measured, cut through the air. "Representative Mamdani," Jackson began, her tone direct, "you've eloquently argued that this legislation is vital for protecting our democracy. Yet your public advocacy has also stressed the importance of local control and community-led solutions to systemic issues. How do you reconcile that philosophy with a federal bill that centralizes significant election authority, potentially diminishing the very local engagement you champion?" The chamber gasped. Veteran court reporters froze, pens hovering above notepads. This was unprecedented. A Supreme Court justice directly challenging a prominent state legislator during oral arguments, not on ideology, but on the coherence of his own progressive philosophy. The atmosphere crackled with tension as cameras captured Jackson's probing expression and Mamdani's momentary pause. But then something unexpected happened. Instead of retreating, Representative Mamdani slowly stood, straightened his blazer, and approached the microphone. What he pulled from his folder next left Jackson visibly stunned and would change the course of one of the most significant constitutional cases in decades. No one could have predicted that in the next 15 minutes, Mamdani would not only defend the bill's constitutional foundation, but completely turn the tables on Jackson with evidence that would leave the entire Supreme Court bench speechless. Before we dive deeper into this extraordinary showdown, take a moment to like this video and subscribe to our channel for more breaking political analysis that the mainstream media won't show you. Hit that notification bell so you don't miss our exclusive coverage of the biggest political battles happening right now. Justice Ketanji Brown Jackson sat tall at the Supreme Court bench, her black robe pristine, her expression keen yet composed. Appointed by President Biden in 2022, Jackson had quickly become known for her meticulous legal reasoning and deep understanding of how laws impact everyday Americans. The first black woman on the court, the former public defender, district and appeals court judge, brought a unique perspective, often emphasizing the lived consequences of legal decisions and the historical context of constitutional protections. Today's case involved a challenge to a new federal voting rights bill, the Democracy Restoration Act, which New York State Representative Zohran Mamdani had passionately championed. The legislation aimed to expand ballot access, standardize election procedures, and implement federal oversight in response to a patchwork of state laws that critics argued created systemic barriers to voting. While Jackson generally supported robust federal action to protect voting rights, her questioning often focused on ensuring such legislation was not only necessary, but also constitutionally durable and effective in practice. She saw the case as a critical test of Congress's power to address systemic issues in voting, while also carefully considering the limits and optimal application of federal authority. For months, conservative media had criticized the proposed law as federal overreach, an attempt to nationalize elections. Right-wing news sites and commentators questioned whether Mamdani, a prominent Democratic socialist, was pushing an agenda that would undermine state sovereignty and local control. Representative Zohran Mamdani, 33, had risen quickly in New York politics after winning his Astoria, Queens State Assembly seat. A graduate of Fordham Law, Mamdani had earned national attention for his articulate advocacy, often framing issues through the lens of systemic inequality and the need for bold democratic solutions. When fundamental rights are systematically denied or undermined at any level of government, federal intervention becomes not an intrusion, but a constitutional imperative, Mamdani had told reporters the previous week. This bill ensures that every eligible American can exercise their constitutional right to vote without unnecessary barriers imposed by partisan interests. These comments, particularly his nuanced critiques of judicial overreach, had apparently piqued Justice Jackson's interest. While a progressive, Jackson was known for rigorously challenging arguments from all sides to ensure their constitutional soundness and practical efficacy. As the Supreme Court session began that morning, the chamber was filled to capacity. Legal experts from both sides of the aisle packed the gallery. CNN and Fox News had reporters positioned outside, ready to broadcast reactions. Constitutional scholars had predicted a routine of tense proceeding. No one anticipated what was about to unfold. The Solicitor General had just completed her opening defense of the Democracy Restoration Act when Justice Jackson unexpectedly focused her attention directly on Representative Mamdani, who was seated in the front row of the gallery as a key advocate for the legislation. Before we continue, I'd like to address Representative Mamdani directly, Jackson said, breaking normal court protocol. Chief Justice Roberts looked surprised but didn't interrupt. As Jackson continued, Representative, you've publicly championed this legislation, stating that federal intervention is a constitutional imperative to address systemic barriers. Yet, you've also stated that the Supreme Court needs to recognize the distinct roles of the branches and avoid substituting its judgment for that of a democratically elected Congress on matters of public policy where constitutional authority is clear. While this court unequivocally respects congressional prerogative, our constitutional duty requires us to review legislation for its adherence to the Constitution's text and structure. Your statements taken together suggest a tension between advocating for broad federal power and acknowledging the judiciary's essential role in defining its limits. Can you explain how you reconcile this view with the principle of judicial review? Court observers exchanged shocked glances. This direct confrontation was almost unheard of in Supreme Court proceedings. The Chief Justice shifted uncomfortably, but remained silent as Jackson continued her pointed critique, not of Mamdani's motives, but of the intellectual consistency of his argument in the face of the court's institutional role. It was a sophisticated legal challenge, broadcast live to millions of Americans. What no one realized was that Representative Mamdani had anticipated this moment and had come prepared with evidence that would stun the court and the nation. The Supreme Court chamber remained frozen in shocked silence. Justice Jackson's unprecedented direct challenge to Representative Mamdani hung in the air. The Chief Justice, finally recovering his composure, leaned toward his microphone. "While this is highly irregular," Roberts began, "since Justice Jackson has addressed the representative directly, I'll permit a brief response before we return to proper procedure." All eyes turned to Representative Mamdani, who nodded respectfully to the Chief Justice. As he rose from his seat in the front row, his expression revealed not intimidation, but calm determination. Court security initially moved to prevent his approach, but Roberts waved them back, allowing Mamdani to move toward the attorney's podium. "Thank you, Mr. Chief Justice," Mamdani said, his voice steady and clear. "And thank you, Justice Jackson, for your direct questions. I welcome the opportunity to address them." Jackson's expression remained engaged, but a flicker of surprise crossed her face at Mamdani's composed demeanor. The representative wasn't rattled as expected. "Justice Jackson," Mamdani began, "you've suggested a tension in my views regarding federal power and judicial review. With all due respect, my position has been consistently rooted in the principle that judicial review is essential to our constitutional order, but that it must be exercised with deference where Congress acts within its clear constitutional grant of power." Conservative justices Alito and Gorsuch exchanged skeptical glances. Justice Thomas leaned back, arms folded. On the liberal side, Justices Sotomayor and Kagan watched with intense interest. Mamdani continued, "My statement about the court needing to stay in its lane was specifically addressing hypothetical questions about the court potentially nullifying certification of election results or legislating from the bench, something entirely different from reviewing the constitutionality of legislation." He reached into his folder and held up a transcript. "The full interview shows this context clearly. I've never questioned this court's judicial review authority established in Marbury versus Madison." Justice Jackson frowned. "Representative, regardless of that specific comment, your legislation's broad scope raises questions about its practical implementation and its impact on the delicate balance of federalism. How does this bill ensure necessary flexibility for diverse state needs while imposing uniform standards?" A tension in the chamber intensified. This was becoming a direct debate between a Supreme Court justice and a state legislator, a rare occurrence. "Justice Jackson, I'm grateful you've raised the question of constitutional balance," Mamdani replied, a hint of confidence entering his voice. Because Article 1, Section 4 of the Constitution explicitly states, and I quote, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations." He emphasized the last part, his legal training evident. The Constitution explicitly grants Congress authority to establish federal election regulations. My legislation operates precisely within this constitutional framework, setting a national floor of protection, not a ceiling, allowing states to innovate beyond it if they choose. Several reporters furiously scribbled notes. This wasn't just a response. It was a constitutional counter-argument delivered directly to a Supreme Court justice. Jackson's expression remained thoughtful. "Representative Mamdani, I'm well aware of the constitutional text. The question is whether your specific provisions, even if facially within Congress's regulatory authority, are proportional and tailored to the constitutional harms identified, rather than representing an overbroad federalization of what have historically been state functions." "I appreciate that concern," Mamdani nodded. "However, Supreme Court precedent has consistently upheld Congress's broad authority in this area, particularly when addressing issues of voter disenfranchisement and ensuring equitable access." He quickly cited 3 previous cases supporting congressional action on voting rights, including decisions from the Reconstruction era. The exchange was becoming a high-level constitutional debate. Justice Kavanaugh leaned forward, clearly engaged by the substantive legal arguments. Jackson shifted approach. "Your public advocacy has often centered on empowering local communities and addressing systemic inequalities through grassroots action. How does this federal legislation, with its top-down standards and enforcement mechanisms, genuinely empower those local communities rather than simply shifting power dynamics?" This was a direct and incisive question, hitting at a core tenet of Mamdani's political philosophy. Mamdani didn't hesitate. "Justice Jackson, the irony of federal intervention is not lost on me as someone who champions local power. However, when systemic barriers to voting are intentionally erected or allowed to persist at the state level, federal intervention becomes not an imposition, but a necessary enabler of true local democratic participation. This bill provides a floor of protection, allowing local communities to engage on an equal playing field. It's about dismantling structures of disenfranchisement so that local voices can actually be heard." The gallery murmured. Mamdani was holding his own against one of the court's sharpest legal minds. Jackson pressed harder. "Yet, the bill includes provisions for Department of Justice pre-clearance of certain state election changes. That framework was specifically invalidated in Shelby County v. Holder due to its outdated coverage formula." For the first time, a faint smile flickered across Mamdani's face. "Justice Jackson, you've raised an excellent point that allows me to clarify a critical distinction." He removed another document from his folder. "The pre-clearance mechanism in this legislation differs fundamentally from the Section 4 coverage formula struck down in Shelby County. This bill establishes objective, contemporary criteria based on proven patterns of voter suppression, which apply prospectively and uniformly to all states that meet those criteria. It addresses precisely the constitutional defect identified in Shelby County by focusing on present-day, evidence-based patterns rather than outdated historical data." The legal reporters in the room looked stunned. Mamdani wasn't just defending himself. He was delivering a masterclass in constitutional law that directly addressed the court's previous concerns, showcasing a deep understanding of its jurisprudence. Jackson's expression remained thoughtful, but her tone had shifted slightly. This wasn't the easy stress test of a politician's argument she might have anticipated. She was engaged in a substantive constitutional debate with someone clearly fluent in the court's own precedents and the nuances of federalism. "Representative Mamdani," Jackson continued, "even if your legislation technically avoids the specific issues in Shelby County, it still represents a significant shift of authority from states to federal agencies. The Constitution's federalist structure suggests the framers intended a more limited federal role in the day-to-day administration of elections." Mamdani nodded respectfully before responding. "Justice Jackson, I share your commitment to constitutional fidelity. That's precisely why I'd like to introduce something relevant to your concern. He removed a bound document from his folder. This is a detailed historical analysis of the framers' understanding of congressional power over federal elections, including statements from Madison, Hamilton, and others. During ratification debates, several justices raised their eyebrows. Mamdani continued, "These sources reveal the framers explicitly intended Congress to have ultimate authority over federal election regulations as a necessary check against state manipulation and potential disenfranchisement." Alexander Hamilton specifically warned in Federalist 59 that, without this congressional power, the exclusion of the national government from regulating federal elections would leave the Union's existence at the mercy of state governments and local factions. The historical evidence was compelling and clearly unexpected. Justice Gorsuch, known for his interest in founding-era understanding, leaned forward with evident interest. Jackson persisted. "Historical evidence aside, Representative, your public advocacy has sometimes suggested courts should simply defer to Congress on these matters. That's not how our constitutional system works." "I agree completely, Justice Jackson," Mamdani replied, surprising many observers with his ready concession. "Judicial review is essential to our constitutional order. My concern has never been about this court's review authority, but rather about ensuring that review is grounded in the Constitution's text and history, including the Reconstruction Amendments that significantly altered the federal-state balance regarding voting rights, empowering Congress to enforce the promise of equal participation." The exchange had now lasted nearly 10 minutes, far longer than the brief response Chief Justice Roberts had authorized. Yet Roberts made no move to intervene. The substantive constitutional debate unfolded. Justice Jackson, seemingly determined to ensure the legislation's most robust defense, shifted focus again. "Representative Mamdani, you've consistently characterized certain state voter ID requirements as unconstitutional barriers. Yet, this court has upheld their validity in Crawford versus Marion County. Your public comments could be interpreted as showing disrespect for that precedent." This accusation hung in the air, potentially more damaging than earlier points. Questioning a politician's knowledge was one thing. Suggesting they disrespected court precedent was another. Mamdani took a measured breath before responding. "Justice Jackson, I have never stated that all voter ID laws are per se unconstitutional. My concerns, consistent with this court's precedents, focus on implementation details that can create disparate burdens on eligible voters, particularly those in marginalized communities. In fact, in my tenure in the New York State Assembly, I co-sponsored legislation that included voter identification requirements, but with robust accessibility provisions, including free state IDs and ample alternative documentation options. My position has been consistent with the balancing test this court established in Crawford, ensuring that legitimate state interests are met without unduly burdening the fundamental right to vote." Justice Jackson appeared momentarily caught off guard by this evidence of Mamdani's nuanced legislative record and engagement with state-level solutions. The tension in the chamber had transformed. What began as a justice's attempt to stress test a legislator's constitutional arguments had evolved into a sophisticated constitutional dialogue that was captivating the entire court. But no one was prepared for what Representative Mamdani would reveal next. Evidence that would completely shift the dynamics of the hearing and leave Justice Jackson genuinely speechless. The Supreme Court chamber remained completely silent as Representative Mamdani reached once more into his folder. Justice Jackson watched with narrowed eyes while the other justices leaned forward, fully engaged in this unprecedented exchange. "Justice Jackson," Mamdani said, his voice now carrying a quiet confidence. "You've questioned how this federal legislation genuinely empowers local communities. Given my advocacy for grassroots action, I want to address that directly by showing why a federal floor of protection is absolutely necessary to allow true local democracy to flourish." He withdrew a document that appeared to be a compilation of internal communications. "My office, in collaboration with several civil rights organizations, submitted numerous public records requests regarding the development and implementation of election policies in various states. We received these communications between a prominent national organization, the Federation for Election Integrity, and state legislators. These documents explicitly state that their model voting bills were designed to consolidate partisan advantage by systematically depressing turnout in high-density urban and minority communities, regardless of the ostensible election security justifications. The chamber erupted in gasps. Several journalists rushed out to report this revelation. This document, Mamdani continued, once the room quieted, demonstrates precisely why the framers wisely gave Congress ultimate authority over federal election regulations as a necessary check against state manipulation for partisan advantage. It's about ensuring local democracy isn't subverted by top-down, state-level strategies to disempower specific communities. Justice Sotomayor leaned forward. Representative Mamdani, is that document part of the official record in this case? It was filed in our supplemental brief last week, Justice Sotomayor, Mamdani confirmed. Page 47, Appendix C. Chief Justice Roberts frowned, flipping through his papers to locate the reference. Several other justices did the same. Justice Jackson, her expression now a mixture of concern and intense focus, attempted to regain control of the exchange. Representative Mamdani, a single email doesn't establish a pattern of, "You're absolutely right, Justice Jackson," Mamdani interjected politely but firmly, which is why we've included 23 additional communications in Appendix D detailing a coordinated, multi-state effort to restrict voting access, specifically targeting communities with historically high minority populations. These communications discuss methods to reduce registration numbers in urban centers and streamline polling access in rural areas without providing equivalent resources to diverse urban districts. He didn't wait for a response before continuing. But most relevant to today's discussion is Appendix E, which contains communications directly citing this court's past decisions that weaken federal oversight as the green light to implement Phase 2 of the Election Security Initiative without fear of robust judicial intervention. The chamber fell completely silent. Mamdani had just revealed that documents suggesting certain state officials viewed the court's previous rulings as permission to implement voting restrictions they believed would go unchallenged, underscoring the urgency for congressional action. Justice Jackson's face remained composed, but her body language evinced deep concern. Representative Mamdani, I had no knowledge of course not, Justice Jackson, Mamdani said quickly. No one is suggesting you or any member of this court are personally involved in such efforts. These communications simply demonstrate why the Democracy Restoration Act has become necessary, and why Congress must retain its constitutional authority to regulate federal elections when states act with discriminatory intent or when a vacuum of federal protection leads to widespread disenfranchisement. It shows that in the absence of a federal floor, the very local democratic participation I advocate for is undermined. The dynamic had completely shifted. What began as Jackson's attempt to stress test Mamdani's progressive arguments had transformed into Mamdani effectively demonstrating the very systemic need for the legislation under review and the real-world consequences of a lack of robust federal safeguards. Justice Kagan spoke up. Representative Mamdani, these documents raise serious factual questions about the motivation behind certain state voting laws. Can you clarify when these were obtained and verified? Yes, Justice Kagan, Mamdani replied. These documents were obtained through legal discovery in parallel voting rights litigation in federal district courts. Their authenticity has been verified under penalty of perjury, and none of the authors have disputed their contents, despite having the opportunity to do so. Justice Kavanaugh, who had been reviewing the appendices, looked troubled. Appendix E's communications appear to explicitly discuss methods to reduce turnout in specific demographic groups, and to do so in response to perceived vulnerabilities in federal oversight. That raises obvious 14th and 15th Amendment concerns, regardless of federalism. Precisely, Justice Kavanaugh, Mamdani agreed. And that constitutional concern is exactly what our legislation aims to address. Not by targeting specific states, but by establishing uniform national standards for federal elections that protect all voters, regardless of where they live or which party they support, thus enabling genuine local democracy. Justice Jackson, attempting to recover from the unexpected turn of events, shifted to procedural grounds. Representative Mamdani, while these documents are concerning if authentic, this court's role is to evaluate the constitutional boundaries of federal and state authority, not to assess the wisdom or motivation of particular state policies. Mamdani nodded respectfully. Justice Jackson, I completely agree. The constitutional question before this court is whether Congress has the authority to establish these particular federal standards for federal elections. My purpose in highlighting these documents is to demonstrate why the framers wisely gave Congress this very authority in Article 1, Section 4, as a necessary check against exactly the kind of state manipulation these documents reveal. It shows that a failure of federal oversight directly enables the erosion of fundamental rights. He then delivered his most powerful point. The Constitution's text, original understanding, and this court's own precedents all confirm Congress's broad authority in this area. The historical record shows the framers specifically intended Congress to have final say over federal election regulations, and the Reconstruction Amendments further empowered federal protection of voting rights. This legislation falls squarely within Congress's constitutional authority. It establishes uniform national standards that apply equally to all states, and it fulfills our constitutional obligation to ensure that the right to vote, the right preservative of all other rights, is protected for every eligible American citizen, allowing their local voices to truly matter. The gallery remained completely silent, absorbing the significance of what they just witnessed. What began as Justice Jackson's attempt to rigorously challenge a legislator had transformed into a masterclass on constitutional interpretation